Ladies and gentlemen, have I got some good news for you. If you were a former Washington Mutual customer that had a loan, such as mortgage, through them, as we know, they were handed to JP Morgan for pennies on the dollar when they collapsed. Except a little issue has occurred in a current court case, apparently, that has proven that JP Morgan was never assigned the mortgages of Washington Mutual. Therefore, if you had a loan, etc., mortgage through Washington Mutual at the time they collapsed and then was handed to JP Morgan, and you're now making your payment to JP Morgan, but you were a former customer of Washington Mutual, and that's who your loan originally was through, JP Morgan is not the owner, has no bill of sale, so to speak, has no bill of goods. They do not own your mortgage. Why are you paying it, is what I'm asking you right now. Get ready for this. This is not something that I said or haven't said before. I've already said this. I've done a couple, well, more than that, probably 3 or 4 different mortgage type videos telling you in advance they never transfer the note properly. And in this case, the FDIC was involved because they closed. That's when a bank gets closed down, they take over and decide, okay, we're going to break it apart, what's left, and give the accounts to so-and-so. And such as in this case, JP Morgan got it. Except there's a little problem. Man, I got to read this to you. August 21st, 2012, headline. Out of the mouth of JP Morgan Chase, quote, schedule of loans purchased from Washington Mutual, also known as WaMu, does not exist. No assignments of mortgage, no allonges, or any evidence of transferring ownership of loans from Washington Mutual to Chase, JP Morgan Chase. Confirming under oath and in print what we already expected, myself included, there is no schedule of mortgage loans evidencing what JP Morgan allegedly purchased from the FDIC in connection with the failure of Washington Mutual. This is from the sworn deposition testimony of Lawrence Nardi, the operations unit manager and a mortgage officer for JP Morgan Chase, who was previously with Washington Mutual and was picked up by JP Morgan after Washington Mutual failed. The 330-page deposition was taken by counsel for the homeowner. I love it. That means a homeowner was fighting and didn't walk away like a mindless bozo zombie sheep, stood up for once and found something amazing, the unthinkable. They don't actually own my note, my mortgage, or anything. Yeah, J-Stip4 has been telling you that for a few years now. The 330-page deposition was taken by counsel for the homeowner on May 9th, 2012, in the matter of JP Morgan Chase Bank, N.A., as successor in interest to Washington Mutual Bank versus WaMu, I guess their last name, Florida 5th Judicial Circuit, case number such and such. Here is the question and answer right out of this deposition. Question. Okay. Are you aware of any type of schedule of loans that would have been created to represent either the loans that were asset loans or the loans that were serviced by Washington Mutual? Do you know if there is a schedule or database of loans like that? Answer. Basically from JP Morgan. I know that there was a schedule contemplated in certain documents related to the purchase. That schedule has never materialized in any form. We've looked for it in countless other cases. We've never been able to produce it in any previous cases. It would certainly be a wonderful thing to have, but it's, as far as I know, it doesn't exist, although it was contemplated in the documents. And then the guy comments on this blog or whatever, as we all know, JP Morgan has also stated in a federal court filing that it is not the successor in interest to Washington Mutual. However, the deposition testimony gets even better as the day went on. And here's the rest of it. Question: have you ever, in your duties of being a loan analyst, a loan operations specialist, have you ever seen an FDIC bill of sale or a receiver's deed or an assignment of mortgage or an allonge? Answer: for loans, I'm assuming you're talking about the Washington Mutual loan that was subject to the purchase here. Yes, that's correct. No, there is no assignments of the mortgage. There's no allonges. There's no, in the thousands of loans that I have come into contact with that were a part of this purchase, I've never once seen an assignment of mortgage. There is simply not. They don't exist. This is his statement. Or allonges or anything transferring ownership from Washington Mutual to Chase, in other words. Specifically in endorsements and things like that. I think this guy's about to wind up dead. So that's the end of the conversation, and then back to the blog. So JP Morgan allegedly purchased mortgage loans from the FDIC out of the Washington Mutual failure, but there is no schedule of what loans were purchased, no assignments, no allonges, no endorsements, nothing that transferred ownership of the loans from Washington Mutual to Chase. However, as we all know, JP Morgan goes around the country touting that it is the successor in interest to Washington Mutual, which it has admitted in federal court that it is not, and relies on the amorphous FDIC affidavit. We've got an FDIC affidavit, which, as far as what the affidavit is pro-offered for, is directly contradicted by the sworn deposition testimony of JP Morgan's authorized representative, who was formerly with Washington Mutual and was picked up by JP Morgan. And he says, fraud in the courts, anyone? Wow. This is not American Idol. This is breaking news. This is not something that I didn't say before. I've already said it. If you're one of those people who had a loan, mortgage, and you got a letter in the mail, hey, you no longer have your mortgage through this guy. We're the new guy. We purchased it from them. Start making your monthly payments to us now. Oh, okay. Month, 2 months, 3 months later, whatever, another letter comes in your mailbox. We are your new loan holder or whatever, mortgager, mortgage company. Formerly, you were paying so-and-so. Now you need to start paying us because we purchased the loan. Some people have gotten 5 of those things. Some people 3, whatever. Most people, including myself, got more than 1. I think I got 3 in total. That pretty much guarantees you, by the way, if you're one of those people, and not just one of those letters. Usually one's not enough. It's usually when you get 2 or 3 of those letters, when it transferred 2 or 3 hands, that's usually solid for you to be on what I call Jason Ip4's list of people who basically are paying a mortgage who shouldn't be, because you're not even paying the person who legally owns your house. And if they ever, some kind of major court case comes up in the future after you've been paying this alleged new guy, I've been paying him for 7 years now, and then one of the old guys stands up and says, wait a minute, I've got the last signed note when it was transferred to me. I never signed it and transferred it to this guy, and he therefore couldn't have signed it and transferred it to that guy because I never physically signed it, even though we used the MERS mortgage registration online system. The law doesn't allow you to use MERS instead of the note signing practice, which was what basically the law requires. You must sign the note, hand it to the next guy. You are now the rightful owner, and if you want to sell it and bundle it with other packages to sell to somebody else, you better sign it. The chain of title, as that's called, must be true and correct all the way down the chain, all the way down the sale after sale after sale. If there's a break in the chain of title, you should go seek a lawyer if you're thinking about not paying your house, because the chances are you stand a very good chance of winning. And I've come to find out after many long weeks and months of researching this long ago that probably at least 8 or 9 out of 10 people in America with a mortgage are actually the example I just gave in that situation, and they don't even know it. 8 to 9, maybe whatever, out of 10. So there might be 1 or 2 legitimate mortgages, period, out of 10. For every 10, there's 1 or 2 that are good. This is massively bad for JP Morgan, and it makes me feel so good when the old JP Morgan cringes and curls up. Oh, they're shining that light. Oh, that truth. Oh, they're exposing the evil. We're burning like a vampire in the night that turns to day and the sun's coming out. It's burning his skin and it hurts. No. And I'm the guy with the big mirror reflecting the sun. Where's old Jamie? Oh, he's got Jamie Diamond Eyes. Hey, he's got Jamie Diamond Eyes. Oh, now they're on fire because he's a vampire. So this is incredible. This guy's sworn testimony. We don't have it, never had it, thought it would be a good idea to have. We talked about having it, but we never had it. That's his answer. We had many discussions that it would be a good idea to get this, but since it didn't exist, we can't use it. But we did talk about using it. We did talk about using it. Does that count? We talked about it. Allegedly in the court of law? No, it doesn't count. We need the physical goods, and you don't have them. Therefore, if you're a Washington Mutual former mortgage company through them, your mortgage was through them, you probably got a note. You need to start paying JP Morgan all of a sudden. This would have been years ago, several years ago. Which also means you've been giving that money away for free to JP Morgan this whole time. And what if, again, the guy who rightfully owns it somehow realizes, hey, what's left of Washington Mutual actually owns the mortgage. We're going to go to court. They go to court. Court rules, technically speaking, what's left of Washington Mutual, if there is such a thing, is the rightful owner of all these mortgages. So you call or maybe you knock on the door of JP Morgan. Listen, I've been paying you for several years now because I thought you were rightfully the one that got Washington Mutual for pennies on the dollar, of course, fire sale. And essentially you got my mortgage. So I just found out that I've been paying you for the last several years, every month, $1,400, $2,000 a month, whatever your mortgage is, right? Times several years, man, that's a lot of money. And you didn't own the house. That's illegal. And I now owe it to this guy over here, the former entity known as Washington Mutual, who now is coming to me saying I need to start paying him 4 years, 3 years, whatever, of back payments that were owed to him. And you've got my money. You need to refund my money. JP Morgan's response will be, go pound sand, we're filing bankruptcy, you get nothing. And, which means your money doesn't get refunded. You still owe 4 years of payments to the guy who stood up and said, I'm rightfully the owner of the house or the mortgage. What's left of Washington Mutual, if there is such a thing. And they would rightfully be able to demand 4 years of payments, or however long to the day it was that they collapsed, so about 4 years ago. Then they would have the right to ask for and say, hey, it's been 4 years, this lump sum. And then you would argue back, well, I gave that 4 years to JP Morgan. And JP Morgan would say, but we're bankrupt. We don't have to pay it. We filed for bankruptcy. The money's ours. Go pound sand. And people think I'm out of my mind for not paying my mortgage when I did the research and found out, oh, I qualify for the same thing. Bank of America thinks they own my house. I was formerly with Countrywide. And a same kind of similar thing happened with Washington Mutual with Countrywide, where they were shotgun married off to Bank of America. And they used to call me, sir, you're behind, and when are you going to start making payments again? When I just need to update my notes. Can you tell me? They would get to the point because so many people were probably screaming their head off at these phone calls. I don't have the money. I can't make the payment. Not me. I was very calm. So, but they don't know that when they're calling. They're expecting someone to scream at them. And these people are probably very upset during their work days and probably very stressed out So right off the bat, they say, "Hi, I'm with Bank of America." I just need to update my notes, sir. Can you? That's all I need. I just need to update my notes. In other words, tell me anything as to why or when could I expect a payment. And I said, honestly, I don't know. I don't know when I'm going to be able to make payments. Sir, just give me anything. 3 months, 6 months. I just got to put something in here. Yeah, put whatever you want. 6 months. It's fine. Okay. All right. Take care. Bye. That was it. But I'd get those calls every month. And I was doing my research and said, you know what? I'm not going to play that game. I'm going to handle this legitimately, legally, the way it's supposed to be handled. So the old phone rang one day, and I've done this video in the past, but I know I've got a lot of new subscribers, so this is a bonus for my new subscribers. Me repeating this. Did the research, contacted a local guy that was working for an attorney, boom, boom, boom. Checked out this, and this. Sure enough, old JSnip4 is in that category of, hey, you probably should stop making your mortgage payment because they may not even own the house. And you're giving away money every month to someone who doesn't legally own your house. Stop. That's what he told me. So I stopped. And they called, Bank of America. And I told them, you're taking notes again, right? You need to update your notes? Yes, sir. All right, make sure jot this down. All right, ready? Yes. Okay. I've done research on my house. I've checked the chain of title, the note, a few other things. Some forged document problems. And I've determined that there's a massive break in the chain of title. And when that occurs, no one knows who the rightful owner is. My lawyer advised me to stop making payments immediately because one thing he assured me is that you can't possibly be the owner due to the break in the chain of title alone, not even including the other issues we found. So he is advising me to stop making payments because if the prior party or parties prior to the prior party stand up and say, hey, we're the rightful owners, that means I've been paying you this whole time and you don't even own the house. It's like I'm giving you money away for free. And due to the factual problems we found in my chain of title and mortgage documents, I am not making another payment. I said, by the way, I know every now and then you send a letter, and in the title of the letter, the top part of the letter, it says, Dear homeowner, this is Bank of America, LLC, NA, whatever, subsidiary, Bank of America. We are the servicer of your note to note holder. We are servicing your note for note holder. Who is note holder? Is that like a first and last name of somebody? Of course not, but I asked her, what is note holder? Shouldn't that statement say, we are Bank of America, we service your loan for note holder XYZ company? Or XYZ investment, something. Well, yeah, but we don't reveal that information. We don't tell anybody who the investors are. That's private information. So that's why we just put note holder and the note holder after it. It's just a general term. Well, since they're the rightful owner of my note, technically, as you're saying here, I need to know who I'm paying. So who is the note holder? You'd have to take us to court for that, sir. And then we would be able to disclose that. Oh. I've got a better idea. You're going to have to take me to court because we really need to get to the bottom of who really owns my house. And I'm not going to hurry that process by taking you to court and paying fees to start that process. I'll let you guys deal with that because I don't think you're the rightful owner of my house anyway, and my documentation pretty much proves that. So you're going to have to sue me. Did you get all that in your notes? Yes, sir. Thanks. Have a nice day. They have never, ever called back since, and that was a good while ago, probably a year and at least a year ago now. It's got to be at least a year that they stopped calling after I gave them that speech. Why would they stop calling? Why would they stop pursuing this if I owed it to them? I mean, if I owe it, I owe it. If it's legit, then it's legit. You need to collect on that. So I got a letter the other day. I don't know if I mentioned this on YouTube or not. This was probably a few weeks ago. Out of nowhere, such and such law firm. We represent Bank of America, blah, blah, blah. I don't know if it used the term represent, but it's, regarding your home loan, blah, 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 Bank of America. And, It almost looked like a collection letter, like as if the bank sold it, as if it was a faulty, deadbeat credit card debt. They sold it off to some debt collection company, which is usually a law firm, by the way. A lot of law firms buy them. And it looked at the bottom of each page, back and front, said, this is a notice to collect a debt. That's required by law that they state that. Now, any letter from a lawyer wouldn't say that if they're just working with the bank as their representative to tell me, hey, you need to pay this back or we're going to foreclose on you. Not this is an intent to collect a debt. If this is not your debt, please respond in writing to the above mentioned address. And JSNIP 4 is very knowledgeable about that process and what happens if you don't respond. So I responded. Certified mail. Absolutely must be certified mail, by the way. Respond back. 3 sentences. Because it was addressed to myself and my wife, since she lives here. That's automatic. My wife, in regards to the letter you sent, my wife, Evelyn, and I, first sentence, this is not our debt. We do not owe this debt. We dispute the validity of this debt. Signed, which you don't have to sign, by the way, actually. Put it in a letter, go right down to the post office, certified mail, right in my face. I didn't put it in the box because, again, it needs to be certified. Went down to the post office, certified, thank you. I'll take that back. And I got my little stub that will prove in a court of law, of course, if that day ever comes. I sent this, replied back to them, certified. Because if you don't dispute the validity of the debt and you just ignore the letter, that gives them the right to go after you via what is called an account stated claim in court, which means I've been sending this person these bills. He's not acknowledging them. He's not saying anything. He's not replying back saying they're not his. Therefore, he owes it, and we're going after him in court. That gives them the ability to go after you for an account stated. You did not deny that this was not your debt. Just because you didn't respond, that's not a valid answer as far as the law and legality of it is. You got to respond. So I knew that. I responded. This is not my debt or my wife's debt. We do not owe this debt. We dispute the validity of this debt. Signed, sent. Goodbye. Good day, sir. Haven't heard back yet. And if they decide that, hey, they're going to somehow, maybe they're working with Bank of America and they want to finally go ahead and foreclose on me, I would love for that to happen because I would broadcast on YouTube constantly the updates of what's going on, what we're doing, what we're filing, etc. And this guy that I talked to years ago that told me all this, that checked my stuff, told me what to look for, whatever, he's on standby for the day that I get that letter. You've got 20 days for court summons. You're being sued by Bank of America, foreclosure, blah, blah, blah. And I'll have 20 days to respond. I know that whole process. But I will then hire him. And it costs $4,000. But I will hire him, and no matter how long the court case takes, no matter how much running around, showing up, all that they have to do for me on my behalf, the lawyer, they'll do it. And not keep paying us. We need more money. It's stretching out longer. It's a $4,000 flat rate fee. Have a nice day. And I haven't had to contact him because I haven't been foreclosed on. Haven't got a letter saying they're going to foreclose. And with this, and I can assure you, every month when they're supposed to do their monthly calls to all the deadbeat non-payers, hey, who's this guy? Oh, JSNIP 4 in here. Not really JSNIP 4, you know that, but JSNIP 4, hey, what's C management, C comments in red. Forged documents, chain of title, MERS registration. Yeah, management approval to skip this call, absolutely. Put it back in the queue. Matter of fact, take it out of the queue, send it to management. It's going to sit in a pile over there and rot. Because this guy knows what the hell he's talking about, what we've done. We don't want to go there. Don't bother him. I haven't been contacted in over a year easily. That's all I got for you right now. I would upload this tonight, but it's too late. I'm going to wait till the morning. Take care.